not right. In the consumer proposal about the viability of the water plant being done through additional advisory opinions, isn't that question about the viability more appropriate for the final hearing?
Of course, it could be addressed in the final hearing, but since it is essentially a preliminary submission that is necessary to make the application complete, the way these rules work is an application does not even move forward until it is determined to be complete. This board has already ruled that the absence of the water plan renders it incomplete. I believe that in terms of judicial or administrative efficiency, it makes sense to address whether or not this plan is viable and did in fact render the application complete. The way the rules work is once it's complete, we then move forward to the hearings. Otherwise, people are spinning their wheels doing so many other things that that might not be necessary if it's determined that this water plan simply, let's assume for the sake of argument that I'm right. And it turns out that the water plan is not legally enforceable. The contracts are not at all contracts, it's not enforceable. Or that the vote by the town of Johnson is determined to have been in violation of the Open Meetings Act and the vote is declared null and void. If one of those things happens, or if the legislature passes a law that makes the carrying out of this contract legally impossible, if any of those things happen, then the completeness of the application is clear. It's incomplete. It remains incomplete. And I believe that's a condition precedent to move forward. Could you do it the other way? Sure you could. I don't think that's what the Act requires, and I don't think that is sufficient.
Anything further on the motion? I think we should take the motion through, take the motion under advisement. But I'm asking for your, but I'm okay with this, like, and both parties have given us a lot to think about. The information has been submitted, so we can explore.
Could we ask the coordinator, do we have a later date? I mean, there's been a lot of good arguments and information here. I wouldn't want to put out the vote on this motion to dismiss for too long.
Director, you have a number of active dockets, so we do have some dates reserved. I checked, and the next available date for the board is February 16th. I have a few hours reserved on your calendar starting at 2 p.m.
So, a couple of thoughts here. It sounds like we're talking about taking this all under advisement, everything we heard, and having a meeting later in February to vote on these motions. I'd like to just comment that I think we got beyond these motions and some of what we're talking about today, but one of the things on my mind is the statutory timeframes and the various elements of the statute regs in regard to should we deny the motions, where are we in the process in terms of 180 days required to get advisory opinions on elements of this application. Clearly the burden is on the applicant. There are areas where there's questions that need to be answered and evidence that needs to be presented, and we've all acknowledged that would happen at the final hearings. So if you prefer to wait until a date and vote on it, that would be fine with me.
All right, then we will do. Is there anything further?
Point of clarification, whether you have or have not set 2 p.m. on February 16th as the open meeting to consider the two pending motions to dismiss? And if not, what the date may be, or if that'll be determined at a later time?
I'll ask the coordinator.
So I do have that time reserved. It would be perhaps difficult to find another time, but I am required to provide, you indicated an open meeting, so I will provide official notice, and my understanding is that's when it becomes officially scheduled.
But in the meantime, we ought to save 2 p.m. on the 16th on our calendars.
Yeah.
Thank you. That's what I wanted to know.
I think we'll be seeing each other at 2 p.m. on the 16th.
Thanks, Karen. Thank you very much. We're adjourned.
I'll make a motion to adjourn.
A second. All in favor?